And I believe our second speaker will elaborate on a little bit more on these issues. And our second speaker is Professor Kentaro NISHIMOTO. Professor NISHIMOTO is a professor of international law at Tohoku University and Arctic Observation Center, National Institute of Polar Research in Japan. At Tohoku University, he is the vice director of the Center for International Law and Policy. His research focuses on the international law of the sea, including issues such as the history of the law of the sea, sustainable development of ocean resources, and the settlement of maritime disputes. His recent publications include a co-edited book on maritime biodiversity of areas beyond national jurisdiction, and also new developments in the law of the sea on areas beyond national jurisdiction. He has advised the government of Japan in various capacities, including as an advisor to the Japanese delegation to the BBNJ PrepCom, as well as Intergovernmental Conference. Professor NISHIMOTO?
Thank you very much for that very kind introduction. And before I begin, I would like to thank the hosts of the conference, the Ministry of Foreign Affairs of the Republic of Korea, the Korean Society of International Law, and also the International Tribunal for the Law of the Sea for this opportunity to give a presentation today at this very important event. It is my great honor and privilege to be a part of the distinguished line of speakers and commentators. And although the title of my presentation in the program and also on the slide only refers to dispute settlement, I would like also to address the issues of principles contained in the agreement so as to contribute to the discussion in the panel. And on principles and dispute settlement, I would like to consider the achievements of the agreement in progressing towards this objective of ensuring conservation and sustainable use of areas beyond national jurisdiction, but also consider whether there were any missed opportunities in designing the agreement so that we might be able to identify any further areas for development once the agreement enters into force. And as already discussed in several presentations, Article 7 of the BBNJ agreement lists principles and approaches that the parties to the agreement are to be guided by in achieving the objectives of the agreement. The legal implication of the term "shall be guided by," which follows the wording in UNFCCC, is somewhat ambiguous. However, it is reasonable to assume that the parties are legally required to take into account the principles and approaches when deciding on any course of action in relation to the agreement. Such guidance is particularly important in the context of collective decision-making through the conference of the parties. And in this regard, I would submit that the list in Article 7 is significant in at least two ways. First, it incorporates the principles and approaches reflecting what we now understand as essential elements of good ocean governance. Second, it creates an interlinkage between the issues of conservation and sustainable use of BBNJ and other related issues, and by doing so, facilitates integrated decision-making by the parties. And among the list in Article 7 are principles and approaches such as the precautionary principle or precautionary approach, the ecosystem approach, an integrated approach to ocean management, and the use of best available science and scientific information, which all can be said to be well-accepted approaches to good ocean governance. Some of them are increasingly being recognized as reflected in provisions of Part 12 of UNCLOS or as principles which have or which are close to becoming established as a principle under customary international law. However, in the absence of a direct reference, the explicit confirmation that they are relevant to the governance of BBNJ and represent the elements of a framework for decision-making under the agreement is still important in strengthening the legal framework for the governance of areas beyond national jurisdiction. On the other hand, what might be argued to be a limiting feature of these principles and approaches is that they are of varying status under international law and are at varying levels of abstractness in their normative context. For example, the formulation of item E, the precautionary principle or precautionary approach as appropriate, in itself reflects divided views on the status of precaution as a principle or as an approach. Also, in terms of the abstractness of their normative context, approaches such as the ecosystem approach and an integrated approach to ocean management are generally understood to lack a clear legal definition, although, of course, certain understandings have been developed under specific treaty regimes. This arguably makes it difficult for relevant principles and approaches to guide the parties in reaching a clear interpretation of what are contained in the agreement. However, once we move from definition to regulation, to use the wording of the theme of the conference, the legal status of the principles and approaches are actually irrelevant in Article 7. The parties are to be guided by the listed principles or approach, regardless of its origin or status under general international law. And when we think of the negotiating phase, it is understandable that some states were reluctant to have in the list principles and approaches other than those well established under international law, because their open-ended nature makes it difficult to determine what they are agreeing to in this article. But I think this makes it all the more significant that there's now a commitment to well-accepted approaches to good ocean governance, despite their open-ended nature. And while the lack of the ability to prescribe specific legal outcomes may limit the functions of these principles and approaches in helping to achieve a clear interpretation of the agreement, principles and approaches also play a role in certain other contexts, and this would include where states participate in decision-making in the COP of the agreement. And since the main function of the agreement is more about establishing a legal framework for coordination, cooperation, and in some contexts, decision-making, rather than prescribing static rules, the open-ended principles and approaches can be very helpful. That being said, perhaps one shortcoming of Article 7 is that the list is not well structured. The list appears to be a mix of principles and approaches with varying levels of abstractness, which is presented in an order which does not appear to follow a certain clear structure or hierarchy. As such, it seems difficult to deny that Article 7 fails to present a normative foundation for the legal framework, in the sense that it is somewhat difficult to consider it as a systematic representation of the normative pillars for the entire agreement. But I think that in itself is a reality of how these articles are negotiated. The second significant aspect of the list is that the list of principles and approaches in Article 7 is that it creates an interlinkage between conservation and sustainable use of BBNJ and other interrelated issues. And what stands out in this context is that paragraph H, which that provides an approach that builds ecosystem resilience, including to adverse effects of climate change and ocean acidification, and also maintains and restores ecosystem integrity, including the carbon cycling services that underpin the role of ocean in climate. I must admit that it is not entirely clear how this approach would be implemented in practice. However, the mere fact that this approach highlights ecosystem resilience in relation to the adverse effect of climate change and ocean acidification is in itself very significant, as it directs the parties to the agreement to incorporate considerations relating to climate change. And of course, the nexus between the protection of the marine environment and climate change is an issue on which an advisor opinion is being requested from ICLS in relation to the UNCLOS obligations. But for the parties to the BBNJ agreement, there is more clear guidance under Article 7 to take climate change-related considerations into account. The paragraph J and K also create another type of linkage between the BBNJ and the rights of indigenous peoples and local communities. The paragraph K provides that the parties must be guided by the following: the respect, promotion, and consideration of their respective obligations as applicable, relating to the rights of indigenous peoples or as appropriate local communities when taking action to address the conservation and sustainable use of BBNJ. Paragraph J, on the other hand, relates to the use of relevant traditional knowledge of indigenous peoples and local communities. The relevance of the rights of indigenous peoples has recently been reflected in another ocean-related treaty, which applies to areas beyond national jurisdiction, which is the Central Arctic Ocean Fisheries Agreement. However, I think we could say that the BBNJ agreement is the first major ocean-related treaty to include a reference to the rights of indigenous peoples, which have often gone unaddressed in interstate relations. And while this guidance does not create additional obligations, it does facilitate the integrated decision-making that takes into account the rights of indigenous peoples and local communities. And if I may add, in relation to this, what may be considered missing from the agreement is a link between human rights and BBNJ more generally. Last year, the UN General Assembly adopted a landmark resolution declaring the right to a clean, healthy, and sustainable environment as a human right. The nexus between the law of the sea and human rights issues is an area that was discussed yesterday. And I believe it is a neglected issue, but is now receiving more increased attention. The ecosystem services that marine biodiversity provides are relevant to the enjoyment of human rights in this context and may be seen as an issue that could be further addressed in the future. And now it's somewhat difficult to discuss the issue of principles without referring to the principle of the freedom of the high seas and the common heritage of humankind. The Article 7 reflects the compromise in which both the freedom of the high seas and the common heritage of humankind are included. And this issue, of course, has been discussed in various presentations already, including one by the previous speaker. But maybe just one observation that I would like to add is my view that the compromise may not be a problem for the issue of benefit sharing of marine genetic resources. Since the agreement clearly provides the basic rule that monetary benefits shall be shared, and also establishes a clear procedure for deciding the modalities of that monetary benefit sharing, coupled with a regime for the interim period. The list of principles and approaches in Article 7 also includes the principle of equity and the fair and equitable sharing of benefits in item D, which could be regarded as providing a more direct basis for the benefit sharing regime. Thus, in the next phase, it may be possible and also even desirable to do away with the emphasis on the issue of marine genetic resources when considering the common heritage of humankind and the freedom of the high seas. After all, these are fundamental principles relating to areas beyond national jurisdiction with far more implications beyond just marine genetic resources. So now next I would like to move to the part of my presentation on dispute settlement. And my discussion on this issue also focuses on the achievements of the BBNJ agreement and any possible missed opportunities. And I think the basic question is how successful were states in designing a dispute settlement procedure for facilitating the effective implementation of the agreement. And in considering this question, I would like to discuss the main features of Part 9 on dispute settlement, together with some discussion of the negotiating process, which led us to the provisions that we currently have. And this slide attempts, at least, to give an overview of the dispute settlement provisions of the BBNJ agreement, and in particular, their negotiating history. I don't want to torture everyone with meticulous discussion of how the negotiations progressed, especially now that we are in the final session on day 2. But I would like to offer 3 points that I consider worthy of highlighting. First, as the previous speaker also mentioned, the first 4 articles of Part 9, Articles 56 to 59, and the final article, Article 61, were relatively uncontroversial. And these articles reflected well-accepted rules that are in themselves uncontroversial as a matter of substance, and also contained in UNCLOS or the UN Fish Stocks Agreement dispute settlement provisions. In fact, the text of these articles simply repeats or very closely follows the text of the provisions in UNCLOS or UNFSA. And they were introduced at different stages of the negotiating process, but went through only minor changes after they were added to the draft text. An issue that was heavily discussed following the discussion of the previous presenter as well was to adopt a compulsory dispute settlement procedure that follows the system in Part 15 of UNCLOS, and if so, how the relevant provisions would be formulated. And in the final phase of the negotiations, there were 3 options. The first option, as I understand, was to have a compulsory dispute settlement system, a procedure, in accordance with what is provided in Part 15 of UNCLOS. This follows the approach that was adopted in the UN Fish Stocks Agreement. And on the other hand, the second approach the option was to have a non-compulsory dispute settlement. The text for this option contained a reference to dispute settlement by negotiation and then good offices and mediation. There was also a voluntary opt-in to compulsory procedures before international courts and tribunals, and a possible conciliation procedure. And then there was a third option, which was proposed by a delegation in the resumed IGC 5, which was also based on non-compulsory dispute settlement. And among the 3 options, option 1 attracted the most support, but some states were opposed to compulsory dispute settlement and maintained support for the other options. And in the effort to address the concerns of those states, some elements of option 2 and 3 were incorporated into the first option. The main concerns that were discussed, which were heavily discussed actually, related to the application of the UNCLOS dispute settlement procedure, especially to states that are not parties to UNCLOS, and the relevance of the BBNJ dispute settlement provisions to disputes such as those concerning territory sovereign rights or maritime jurisdiction. And in regard to the concerns of states that are not party to UNCLOS, if you look at the different versions of the negotiating text, they reflect various formulas in a search for a balance that would accommodate the concerns of UNCLOS non-parties while not affecting the integrity of the dispute settlement system. The initial approach was that UNCLOS Part 15 provisions would apply mutatis mutandis. However, if you look at the final text of Article 60, it provides that disputes shall be settled in accordance with the provisions in Part 15 of the Convention, and that the provisions of Part 15 and annexes shall be deemed to be replicated for disputes involving a party that is not a party to the Convention. The Convention is, of course, referring to UNCLOS. These points were important for some UNCLOS non-parties, and once any implications of UNCLOS being applicable to them was avoided, there was somewhat larger support from these states to the option based on compulsory dispute settlement. And third, some states opposing compulsory dispute settlement found it extremely important that certain categories of disputes were not subject to the compulsory dispute settlement procedure. And on this issue, a rather broad carve-out is provided in paragraph 9, which, by the way, is not the only carve-out, but one that I will be focusing here, which applies to any dispute that concerns or necessarily involves the concurrent consideration of the legal status of an area within national jurisdiction, and also any disputes concerning sovereignty or other rights over continental or insular land territory or claim thereto of a party. Disputes concerning the legal status of a maritime area or disputes concerning sovereignty or other rights to territory cannot in themselves be disputes concerning the interpretation or application of the BBNJ agreement if we consider that they must be settled on the basis of jurisdictional rules contained in UNCLOS or the law of territory under customary international law. However, if we follow the approach adopted by the arbitral tribunal in the Chagos Marine Protected Areas case, disputes which involve these issues could still arise under the BBNJ agreement, depending on where the weight of the real dispute lies. And in light of this, the carve-out was likely considered necessary to alleviate the concerns of states against compulsory dispute settlement being used to somehow deal with disputes that touch upon these issues. However, this was, of course, a compromise for states favoring compulsory dispute settlement, and perhaps for that reason, it is coupled with a proviso at the end of the paragraph relating to the possibility of dispute settlement under the UNCLOS dispute settlement procedure. And now when we look at the dispute settlement provisions, especially in light of their negotiating history, it stands out that there was much borrowing from the dispute settlement provisions of UNCLOS and UNFSA. The relationship between UNCLOS and the BBNJ agreement would justify, of course, such an approach. It is possible for some disputes concerning the BBNJ agreement to also arise under UNCLOS or other related treaties such as UNFSA or even the constituent instrument of an RFMO. And in this scenario, the issue of treaty parallelism, which was something that was raised in the Southern Bluefin Tuna case, could arise in an even more complex form. And when we consider this, having dispute settlement provisions that follow the UNCLOS approach would ensure that regardless of whether a dispute is formulated as a dispute arising under UNCLOS or a dispute arising under BBNJ, the result would be the same, that the compulsory procedures based on UNCLOS Part 15 would apply. So this result is also welcome from the perspective of ensuring the rule of law in the oceans. And it was also a very practical approach because the UN Fish Stocks Agreement had already adopted such an approach to dispute settlement. That being said, as an academic, just observing the negotiations while also advising the delegation using using different hats, from an academic perspective, it appears that the fact that types of disputes or the nature of disputes under UNCLOS and BBNJ may be different was not seriously taken into account, and I found that to be somewhat troubling. UNCLOS Part 15 has its own existence, own reasons for its existence, which may or may not be necessarily shared in the context of the BBNJ agreement. And some authors have already pointed out that traditional bilateral dispute settlement may not be sufficient in resolving disputes under the BBNJ agreement, which may involve the infringement of community interests that may not be broken down into individual state interests. And if we look at the BBNJ agreement, and I think this point was raised by a number of presentations today and yesterday, many key obligations of states under the BBNJ agreement can be considered as having such a nature. A party may not necessarily be hindered from invoking the dispute settlement provision to address a violation of an obligation erga omnes by another party. So there may not be an issue of standing if we think about whether using the dispute settlement procedure is possible or not. However, we could have thought about maybe alternative approaches to effectively address issues relating to violations of obligations which are owed to the parties as a whole. And these alternative approaches from the viewpoint of effectively implementing the agreement were not fully explored. And there was also very little discussion on the relationship between Part 9 of the agreement and the Implementation and Compliance Committee under Article 55. And as far as I can tell, the only example of the specific nature of disputes under the BBNJ agreement being taken into account in the design is the existence of Article 59 on disputes of a technical nature. And I think that reflects the understanding that some issues relating to BBNJ can give rise to disputes of a technical nature. The carve-out from the compulsory disputes settlement procedure is something also worth discussing. One issue that was likely in the mind of some delegations was the application of the agreement to the South China Sea. The limitation under Article 60, paragraph 9 covers any dispute that concerns or necessarily involves the concurrent consideration of the legal status of an area within national jurisdiction. Although this language is very broad and would cover waters around Antarctica or issues involving the continental shelf beyond 200 nautical miles where the area is awaiting a recommendation from the Commission on the Limits of the Continental Shelf, there is a rather peculiar, unique situation in the South China Sea that the legal status of the waters was clarified through a binding decision from a tribunal having jurisdiction under UNCLOS Part 15. So questions might be raised regarding whether the status of the high seas in the South China Sea is still an issue that needs to be considered, especially in the case where the Philippines, which was a party to the proceeding, raises a dispute in this regard. The proviso at the end of the paragraph on the applicability of UNCLOS Part 15 could be read as suggesting that it is possible for the maritime jurisdiction component of the dispute to be brought to compulsory procedures under UNCLOS Part 15. And if a court or tribunal having a jurisdiction under the BBNJ agreement was asked to decide the BBNJ dispute based on the decision of a court or tribunal having jurisdiction under UNCLOS, there seems to be some problems if the state cannot come back to the court under the BBNJ agreement and ask the court to make a decision premised on what was decided by the court having jurisdiction under UNCLOS Part 15. I think there can be a lot of discussions, various interpretation of the provisions on this point, but I would just like to highlight that there appears to be some uncertainty in regards to what is precisely excluded under Article 60, paragraph 9. So conclude, first of all, there may have been a missed opportunity in designing the dispute settlement procedure of UNCLOS to best address disputes that may arise under it. Of course, a system of compulsory dispute, and I understand this to be a system of compulsory dispute settlement, is in itself an achievement, and an addition based on maybe a kind of a novel approach was too much to ask for, given the very, very difficult state of the negotiations. However, as an academic, also sort of observing the process and participating in a treaty negotiation for the first time, it did strike me that some states were more concerned about the implications of the dispute settlement provisions of the BBNJ agreement for their jurisdictional claims or disputes, rather than so how to design or how to consider a dispute settlement provision that contributes to the effective operation and implementation of the agreement. Looking forward, so the dispute settlement provisions are, of course, already agreed upon, and there is nothing that we can do to do about it. But I think there is still room to discuss the role of a multilateral environmental agreement type mechanism when the COP decides on the modalities of the implementation and compliance committee, because the parameters of that committee, of course, are set out in Article 55, but the actual modalities are to be considered by the Conference of the Parties. The relationship between the role of the committee and the dispute settlement procedures could perhaps play some role in how the modalities should be set out. And also from perhaps a more academic perspective, how the dispute settlement procedure is put into operation will be a very interesting testing grounds for theories related to dispute settlement and compliance mechanisms for multilateral treaties if we start to see cases under the BBNJ agreement, although this is something which is yet to be seen and perhaps something for the future. I hope not the far future, but I think this is something for the future. So with that, I would like to conclude my presentation. Thank you very much for your attention.
Thank you very much, Professor Nishimoto. I cannot believe it, because before we started the discussion, he promised that he will finish his presentation within 30 minutes, and it was exactly the 30 minutes. And thank you very much for your quite comprehensive and yet very analytical review of major principles as well as the dispute settlement system in general.